Hello, everyone. My name is Ariella Wagner. I am the founder of SunRay Construction Solutions, a national preliminary notice service located here in South Florida. Today, we have another fantastic webinar that will be presented by Alex Barthet of the Barthet Law Firm. He's a construction attorney. And today, our topic is working for the tenant. Follow these steps to lien and get paid. I'm very excited about this because we have a lot of our customers that have issues getting paid on tenant work. So without further ado, I introduce the fabulous Alex Barthet.
Thanks, Ariella. Hi, everybody. My name is Alex Barthet. I am a board-certified construction lawyer helping contractors, subcontractors, and suppliers in South Florida with payment and construction disputes. And today we're going to talk about how to get paid and what steps you need to follow when you do work for the tenant on a piece of property. So let's get started. So today's agenda, we're going to cover several questions that I get on a pretty regular basis. The first is to understand why we're even having this discussion. Why does it matter? And I'm going to explain why there's a difference between doing work for a tenant and doing work for the owner. Then I'll explain how to check to see if the work is in fact tenant improvement work. Sometimes you may think it is and it's not, or vice versa, which can be very dangerous. We'll talk about what are the differences in the lien rules between tenant improvement work and other work so that you can secure your lien rights. And then we'll go through some best practices to make sure that you protect your lien rights. And I will go through 3 specific stories of clients of ours that didn't follow those best practices and got burnt. So I'll explain those situations so you don't find yourself in those situations. And if you have any questions, just go ahead and submit them in the GoToWebinar chat box. During the presentation, we will answer all the questions at the end. Make sure not to include any names of people or companies in your question. So let's get started. Why does it matter? Why is it important that we have this discussion? The main reason is that there is a general expectation that if you do work on property, any property, that if you don't get paid and you follow the lien rules, you can sell that property and recover the amount that you're owed. So if you're not paid, you expect to have a foreclosure sale, and at that foreclosure sale, you hope to be able to recover your money. Now, I say hopefully because it's still subject to the equity in the property. So I got a call from a client yesterday. He's owed $100,000 on a piece of property. But unfortunately, there is no equity in the property, and there's a first mortgage and a second mortgage. And the second mortgage holder is foreclosing on the property. It's worth about $700,000. And there's about $800,000 worth of mortgages alone, plus his $100,000. So don't think that having lien rights means you automatically get paid. It definitely is a strong right that you need to enforce because it does help you get paid. But you expect to be able to have that foreclosure sale, sell the property itself, and hopefully recover. The problem that we have is that if you do work for the tenant, and it doesn't mean just you, by the way, it means whoever the tenant hires. So you may be a rental company, a supply house, a subcontractor that has an agreement with a sub or a contractor. The key question is, does the contractor, the person that has the contract with the owner, is that owner, in quotes, the tenant or the actual owner? Because if it's the tenant, then your lien only attaches to the lease that that tenant has to rent the property. It is not attached to the dirt, the property itself. So if you are unpaid and you don't have rights to the dirt, you may only have rights to the lease. Well, that creates a big problem because that lease may be of very low or no value at all, meaning at the foreclosure sale, again, you can follow the same process as you would normally expect, file all your documents, proceed with a foreclosure, but when that foreclosure sale happens, what the court is selling isn't the dirt, but the piece of paper, the lease. And what we typically see happen is that when a tenant is not paying for improvements, they're usually also not paying rent. So as you may decide to pursue your foreclosure on the lease, but that lease may be of no value because they were evicted. And if they're evicted, when you sell the lease, it has zero value. So that is why this matters, because what you are anticipating is securitizing your credit, which is the lien. You may have an expectation that it has one value when in fact it has a very different value or no value. So how do you check if it is in fact a tenant improvement job? So the first question you should ask yourself is, where is the work? What work are we doing? And is it typically tenant work? This should be the first line of defense. Are you doing work in a mall, in an office building, at a restaurant? If you're doing work at places that are usually related to a landlord-tenant relationship, that should already put your antenna up that something here needs further investigation. But that by itself is not the only analysis you need to look at. You need to see who hired the contractor. Now, if you're the contractor, it's a little easier, right? So if I am the general contractor and I've been hired to build out this restaurant, right? Wait a second, it's a restaurant. Maybe it's maybe the person that hired me is the tenant, not the landlord. So you need to investigate that, and I'm going to explain how you do that in a minute. If the landlord is the one that hired the contractor, then your lien rights are likely okay. So for example, it's not that all the work that happens at a mall, for example, is subject to this problem. If the landlord, for example, at a strip mall hires a underground contractor to redo all of the underground work and the parking lot, well, that work is not subject to this problem, right? Because the landlord who owns the dirt is contracting with the contractor, who may contract with you as a sub, who may contract with you as a rental company. So your lien rights in that situation will likely be just fine, because the landlord, him or herself, is the one that hired the contractor. Now, if the tenant hired the contractor, then your lien rights are now potentially in jeopardy, because your rights under your lien flow from the party that hired the contractor and his or her rights in the property. So if I'm the tenant and I hire a contractor, the only right that I have in the property is my lease. So if I don't pay and there's a foreclosure, typically the only right that the contractor has in the property is my lease. So that's where the problem emanates from. Now, even if you were hired by the tenant, what you need to know is, are the improvements required by the lease? Now, you may not know that even as the contractor because you don't have the lease. And it becomes even more of a problem as you move further away from the tenant, right? So if I'm the rental company to a subcontractor, how do I know what's in the lease? We're going to talk about that in a minute. If, in fact, the tenant is required by the lease to do the work that they're doing, and the legal term is the pith, P-I-T-H, the pith of the lease, which is the heart of the lease, requires that the tenant do this work, then your lien rights will likely still be fine. They may be impaired, but more likely than not, they're okay. And I'm going to give you an example of this at the end on where the lease required the work and the lien rights turned out to be okay. Now, if there is a timely recorded lien prohibition in the lease, then you almost certainly have no lien rights in the dirt. Now, what is a lien prohibition? If I'm the landlord, there is a certain law, which we're going to talk about in a minute, that says I can sign a lease with my tenant, and in it I can say, under no circumstances, tenant, can you allow any lienor to put a lien on my property. Then I take that section of my lease and I go to the clerk's office and I record it. Once I do that, that's the timely recorded lien prohibition, then almost in every situation, my property is going to be free and clear of any lien. So this is the key that we're looking for on whether or not this document has been prepared and recorded. So what are the steps that you need to follow to start analyzing the situation? The first thing you should do is pull a copy of the notice of commencement and compare it with the property records or the deed, as well as who is listed as the owner. So if you pull a copy of the notice of commencement, you're going to see who is listed as the owner, and sometimes it'll even say lease improvements, or instead of owner, it says tenant. So these are automatically red flags that we have an issue. But if it's not obvious on the face of the notice of commencement, you can compare it, who is listed as the owner, to the person that owns the property. So if ABC Corp is listed as the owner of the property in the notice of commencement, and you search in the property records to see who's the actual owner of the property and it's XYZ Company, well, now we have an issue, right? We know that the person that recorded the notice of commencement is not the same person that owns the property. So clearly there may be a landlord-tenant relationship. Now, when you use SunRay, they do a lot of this research for you to make sure that the notice goes to the right place. But they're not going to confirm whether or not your lien could attach to the lease or the dirt. So, but they have all of this information available. So you can ask them, and they'll send you a copy of this notice of commencement so you can continue to do your due diligence. It's not that you don't have lien rights. Just to be very clear, even if you do work for a tenant, you still have lien rights. The problem is that that lien may only attach to the lease, not to the dirt. That's what really we're focused on here. You want to search the public records for a copy of this lease containing this lien prohibition. That's the document I told you before. And what will it be called? It'll either be called a notice of lease or memorandum of lease. That's how it's usually indexed within the clerk's office. And the way you're going to find it is you're going to Google the clerk's office or the official records of the county where the project is located. So let's just take an example. I'm a rental company. I'm about to do work at a mall. And I said, well, let me see if this lease prohibition has been recorded. I'm going to go into Google. I'm going to type in Miami-Dade County official records or public records. That'll take me to the public records section of Miami-Dade County. I need to know who the owner of the property is. So I may have to go to the property appraiser website in Miami-Dade County, do a search for the address, and it will say that XYZ Corp owns the property. I'm going to take that name and I'm going to put it in the official record search, and it'll show me all of the documents that have been recorded under that name. And one of them may be a notice of lease or memorandum of lease. I need to now look at that document, because if it exists, then I know that my ability to lien and potentially foreclose on the dirt itself is probably non-existent. Now, there are some specific rules about this document. It has to contain the specific language in the lease that prohibits this lien liability, or it has to have a notice advising you that all of the leases on the parcel, right? Because the parcel for a strip mall is typically one parcel, and it has many units in it. So all of the parcels prohibit liens, and that's in all of the leases. It has to be recorded, now here's the important part, before the notice of commencement for the improvements of the property. So if it's recorded after, you should be concerned, but you still may have lien rights in the dirt. And the terms of the lease must expressly prohibit this liability, which is the lien liability. Those three things have to be in play. And again, most importantly, the notice has to be recorded before the notice of commencement, the lien prohibition notice by the landlord. So let's briefly run through the rules and explain what the differences are. The short answer is none, right? The things that you need to do to secure your lien rights to sell the dirt are effectively the same as the rules that you need to follow to sell the lease. But let's run through them very quickly. It's just, it never hurts to refresh everyone's recollection. The notice to owner must be served no later than 45 days from your first work or delivery of materials on the project, 45 days being the outside-most date. You should do it much sooner than that. Record the claim of lien no later than 90 days from your last work or delivery of materials on the project. Remembering, of course, that 90 days is not 3 months. Some months have more than 30 days. Some months have fewer than 30 days. The 90 days always includes weekends and holidays, except when you count at the end. So you're going to count starting the following day. So if my last delivery of materials was today, day one of my count is tomorrow. I'm going to count every weekend and holiday in between. And then when I get to the 90th day, if that lands on a weekend or holiday, I'm going to roll it to the next day that the court is open in my county. So for example, if the 90th day was a Saturday, I'll roll it to the Sunday, then I'll roll it to the Monday, and if Monday the courts are closed, so I can't record the document, it rolls to the Tuesday. Those are the only time you extend the 90-day period. And always remember, clients don't understand this all the time, you can always record your lien before you finish the work. We have clients that want to exert a little pressure on the owner and contractor to get paid. We tell them, keep working, but lien the job today. So remember that that's an option for you. A few other things to remember. The last work does not include punch list or warranty work. So you cannot count those days as your last day. So if I'm a painter and I show up to do work, and then a month later I come to touch up some baseboards, when I touch up those baseboards, that would likely be considered punch list or warranty work. So my 90 days ran from the month before when I last left the job, not the day I did that warranty work. Last work does include approved change orders. So if I'm doing work today, I'm off the job for a month, I get a new change order to show back up on the job and do some work, and it's an approved change order. My 90 days is not from a month ago, it's from today when I actually did the work under an approved change order. A few other rules. If you have a direct contract with the owner, then at least 5 days before you file a lawsuit, and we typically recommend that you do it at the time you lien, you need to serve what's called a contractor's final affidavit on the owner. And then finally, you need to file your lawsuit to foreclose on your lien no later than 1 year from your last work, from the recording date of the claim of lien. Again, just like the lien, you don't have to wait till the 90th day, and you shouldn't. You should not wait 1 year from the recording date of your claim of lien to file your lawsuit. Typically, unless you have a business reason to wait, we usually recommend that you do it between you start your collection efforts with a construction attorney between 30 and 60 days after you record your lien. Now, we have a handy tool called a Calculien that you can get on the Google Play Store or the Apple App Store that will count notice to owner and lien and bond deadlines for you, so you don't have to count on your fingers, and it will also account for any weekends and holidays, so feel free to download that. All right, so let's talk about some best practices. All of the information I told you, you need to know before you start the work. Finding out any of this information after you're owed $5, $10, $20, $100,000, it's really hard to come back from that because you may have expected to have lien rights and you don't. So these are the things that you need to do in advance of extending credit on a project. So step one, clearly check for that notice of lease. If that notice exists, the notice or the memorandum, depending on how it's titled, almost certainly you have no lien rights on the property itself, only as to the lease. Next, if you are doing work on tenant improvement property, you should not agree to a pay when paid provision. And let me explain why. If you are a subcontractor, for example, and you sign a contract with a GC and it says that you only get paid when the owner pays the contractor, well, that owner may be the tenant. So now the tenant doesn't pay the contractor, so the contractor doesn't pay you under their valid and enforceable pay when paid provision. You think, okay, well, I still have my lien rights. Well, if the tenant isn't paying the contractor, the tenant may not have any more money and may be evicted. And now you're going to enforce your lien rights on a lease that may be worthless. So you may have entered this transaction expecting that you were secured at least in part by your lien rights, only to find out that you have no meaningful lien rights. So we strongly advise clients that if they are doing tenant work with limited or no lien rights, that they don't agree to pay when paid provisions. There is a document you can serve called a demand for a copy of the lease. So when I told you about whether or not certain provisions exist in the lease or not, and you're thinking, well, how do I get a copy of this lease? You can get it by requesting it. It has to be separate and apart from your notice to owner. It cannot be included with your notice to owner. If you want a copy of this form, which is statutory, it has a special warning in it, and it requests certain information, you can go to our website, thelienzone.com/forms. You can download it there, and you can use the notice or demand for copy of the lease if you are doing work on tenant improvement property and you want to get a copy of the lease. You can do that at any time, either before you start the work or while you're doing the work. So let me end with 3 examples of situations where clients of ours have not fared well because they didn't take the steps necessary at the beginning to protect their rights. So one, we had a client who was a contractor who was hired by who he thought was an agent for the owner, but it turned out to be a house guest for the owner. He did about $50,000 of work in this house. He wasn't paid. The person that hired him, that he had a contract with, turned out to just be a house guest. That house guest was then left out of the country. The client put a lien on the property, and the owner of the property said, well, I didn't agree to any of this. And our lien rights, the client's lien rights, were effectively no good because the party he contracted with had no authority to do the work that he did. So the case ultimately settled for a fraction of what the client was owed, but he had a very limited ability to recover any money. He didn't have a contract with the actual owner, and his lien rights didn't truly extend to the owner, who had no knowledge and granted no permission to do the work. The next is a situation in which we represented the tenant. Our client was a tenant of a restaurant and did the build out for the restaurant. Or we hired a contractor to do the build out of the restaurant, many millions of dollars for this build out. Our client, the restaurant, went out of business shortly after it opened. The contractor, who we were in a dispute with, put a lien on the property. Well, that lien only attached to the leasehold interest. Once our client went out of business and could no longer fund its operations, so they ceased operations, the contractor, who had a lien for about $1 million, effectively got nothing, because the lease was the only right that they had a interest in their lien interest in, and we went out of business, and the landlord evicted my client, the owner. So They didn't do any of this advanced work to analyze whether or not their lien would be good. I guess they suspected that our client, the restaurant, would, having spent so much money to do the work, wouldn't go out of business. But when they did, they got nothing. The last example that I can give you is where our client was doing tenant build-out work with full knowledge that it was in fact tenant build-out work of a bar and a restaurant on Miami Beach. The tenant stopped paying, and as we analyzed the situation, we determined that while there was a notice that was recorded by the landlord to prohibit liens, it was recorded after the notice of commencement was recorded for the work that was at issue. So our client was able to get paid by foreclosing the lien because of that mistake that the landlord made in not recording the lien prohibition document in advance of the notice of commencement. That's an example of how a very small technicality can switch who recovers and who doesn't. So let's check to see if there are any questions. While we do that, if you're interested in learning more about construction law topics and collections, you can subscribe to our podcast, which comes out every week, the Lien Zone podcast, where we talk for a few minutes about different lien, bond, contract, and collection issues. Our next webinar and seminar, we do these webinars once a month for free, our next webinar is June 20th from 9 to 9:20, and it is titled Mid-Year Credit and Collection Tune-Up. And then next week, May 21st from 8 to 11, we have our live seminar at the Courtyard Miami West. It's from 8 to 11, and it'll be a deep dive in issues related to getting paid, liens, bonds, and contracts. We'll answer all your questions. It's a very thorough discussion of these topics. You can go to sunraynotice.com/education to sign up for all of our webinars and seminars. Ariella, do we have any questions?
No, we do not have any questions. I just would like to add that in the SunRay application, when you're requesting your notices to owners, you have the ability to request a copy of a lease. So do not worry if you don't have to worry if you're a SunRay customer. You do not have to download forms. You could just go right into the SunRay system and request the copy of a lease. So I just wanted to add that. And if anyone
even better, makes life even easier.
So thank you all.
If anyone has any questions, feel free to send us an email. You can email Ariella or me. We're happy to answer the questions, even if you don't think of them now and you think of them later.
Wonderful. Well, as always, thank you for doing such a fabulous job, and I wish everyone a sunny day.